Anything else, counsel?
Not at this time, Your Honor.
And if the
Defendant
court
is-
is prepared to continue the prior bond to subject to all conditions not explicitly modified by the court on the record today, the state has nothing further.
Animal cruelty delays, firearm surrender, hidden shell casings, and competency concerns collide inside this packed Kansas courtroom. One defendant pushes a jury trial toward the one-year deadline, while another suddenly takes a plea deal. Stay tuned because the judge is not playing games today. Subscribe now for courtroom breakdowns.
We'll now take up Pinkham on the record. And Mr. Ariano, is he in your office? You need to get him, or is he on the screen? Nope, there he
He's
is.
on the screen. He's blacked out there still, but his name's on there. Mr.
I
Pinkham?
think I see him now. He's started his video. Start your audio. Click on the little red microphone or whatever you have to do to start your audio as well, Mr. Pinkham. Can you hear me, Mr. Pinkham?
Yes, ma'am.
Okay, got a little bit of a feedback there. I don't know if you have any control over that.
Hopefully this is better.
It is better. Thank you, sir.
Good.
On the record in BU 2025 CR 226, State of Kansas versus Mitch R. Pinkham. Please announce appearances.
Jerry here on behalf of the state.
Your Honor, Mr. Pinkham appears via Zoom along with Steve Ariano.
Gentlemen, I show this as a pre-trial conference.
That is correct, Your Honor. I did file a motion to continue it. Amber Norris and I discussed this probably a couple weeks ago, and I filed the motion to continue a week ago. I have a conflict with another case in Reno County, so we are requesting a continuance. The state has no objection to doing so.
This is a misdemeanor cruelty to animal charge, as you are aware. First appearance was June 16th of 2025. So when is our next available jury trial date if I continue this, clerk?
The next jury trial, the pretrial, will be June 22nd, with jury beginning June 24th.
Will the state be able to get witnesses and be prepared for June 22nd with those witnesses?
No objection to those dates and times, Your Honor, if the court is prepared to continue the bond in this case and find this is a defense request for continuance.
All right. Does that date work for you, Mr. Ariano?
I am available, Your Honor.
Okay. This continuance will count towards the defendant's speedy trial time. And the defendant will be continued on the bond posted in the amount of $2,500, June 16th of 2025. Gentlemen, we're passing that mark, so I trust everybody's going to be ready to go. No more continuances.
Your Honor, that would be June 22nd for pretrial.
Right. Okay. June 22nd pretrial, June 24th jury trial, which will have crossed the one-year anniversary of June 16th, 25. So the June 22nd pretrial, June 24th, 5th jury trial. Mr. Pinkham,
That pretrial at?
That will be by Zoom.
What time though? Is that 9?
I'm sorry, 9 o'clock.
Very good.
All right. And is there anything further from either party?
Not from the state, Your Honor.
Very well. We'll be in recess. Mr. Pinkham and attorney are both excused at this time, unless Mr. Ariano, you have anyone else on here?
I have nothing else. Thank you, Your Honor. Have a good day.
Thank you. I'm gonna be just about 1 minute recess. Well, Mr. Beal, who is your client?
Here on Mr. Beeler, that is 24 CR 542.
All right. Well, I show Patrick J. Mitchell. That's what threw me, but you're here as well.
I'm here for him. He's my law partner.
That's what I thought. Okay. So we are on the record in BU 2024 CR 542, State of Kansas versus Scott Michael Beeler. Please announce appearances.
Thank you, Your Honor. May it please the court, Joseph Baca appearing for the state of Kansas.
Scott Beeler appears via Zoom with his attorney, Terry Bell. I appear via Zoom in a different location.
All right, I show this also as a pretrial conference on it's endangerment, reckless exposure to danger of great bodily harm or death, and a misdemeanor, and count 2 interference with law enforcement officer by falsely reporting information intending to obstruct a Class A misdemeanor. And we're set for jury trial. Are we going to have a trial, gentlemen?
No, it appears the parties have reached an agreement. If we
Okay.
could proceed to the agreement in sentencing today.
Absolutely. What is that agreement, please?
He would be pleading to count 2, the interference with law enforcement. Count 1 would be dismissed. There would be no fine, no restitution, very court cost, 6 months of non-reporting probation, and he agrees to surrender his firearm permanently to law enforcement.
All right, let me go through that again. Dismiss 1, guilty to count 2,
Yes,
and no fine, or did I hear a fine?
no fine or restitution.
That no fine or restitution, court costs of
Court cost. Yes.
158, I believe. Okay.
And 6 months of non-reporting probation. And he agrees to surrender his firearm permanently to law enforcement.
Okay, and what underlying sentence should he violate that non-reporting of 6-month probation?
I think it is a Class A, so I think it is a 12 months underlying.
All right, Mr. Baca, is that your understanding of the agreement?
Judge, that is all correct.
And Mr. Mitchell, or Mr. Beal, you and your partner are retained, aren't you? Or is this an appointment?
It retained.
That's what I thought. Okay. If you ever want to take appointments, we always have room for more. Little advertising there. All right, Mr. Beeler, Mr. Beeler, how do you plead to count 2, interference with the law enforcement officer?
Guilty, ma'am.
And by pleading guilty, you're admitting that you did interfere with the law enforcement officer by falsely reporting information that would tend to obstruct the officer in the course of his duties?
Yes, ma'am.
Anyone making you enter this plea at all?
No, ma'am.
And by entering this plea, you understand you're giving up your right to a trial,
Yes, ma'am.
and that you will most likely be found guilty and proceed to sentencing?
Yes, ma'am.
Okay, in your own words, can you tell me what you did that makes you guilty?
Obstructed with law enforcement.
Well, can you tell? That's the legal terminology. In your own words, what did you do?
Withheld information.
What kind of information did you withhold?
I guess pertinent information.
Okay, I want you to just tell me in layman's terms, and what happened? I know you did something that they're saying was, well, here's what they say you did. You falsely reported to a law enforcement officer. What did you report falsely?
We hid. I wouldn't say hid. We threw the shell casings in the trash.
That plea agreement dramatically changes the stakes. Prosecutors dropped the reckless endangerment charge, but the defendant still accepted probation, court costs, and permanent firearm surrender after admitting he misled investigators. The judge carefully pressed for plain language answers, showing how courts demand admissions before accepting guilty pleas. Would you accept?
And what did you tell them about the shell casings when they asked if they did?
That I didn't know where they went.
All right. So this is a crime that started out, it had something to do with shell casings. What were you doing that had shell casings involved?
Defending myself against a intruder.
Counsel, could you take a brief recess with him and kind of clear this up a little bit? Would that
Sure,
help?
if you could give me a breakout room.
Sure. Yeah, clerk, would you please put them in a breakout room, Mr. Beeler and his counsel, Mr. Beal?
They're in that breakout room.
Sure. What's going on?
I have a Tara Ross in the waiting room There's a subpoena for her, but not until Wednesday, so I did not want to let her in without your permission. And there's
Can you
Rhonda.
tell us, have you told her that?
No, I have not, but I can.
Okay, if you would, please. And
And
then,
There's a Rhonda Navare, Navarre. She
And-
has not.
And on Rhonda Navarro, she is the caretaker for Gary Weaver and supposed to have Gary Weaver with her for the hearing this morning.
so is she wanting us to expedite that hearing?
If we can, Judge, he has to have a caretaker, basically.
Is it going to be a lengthy hearing or something we could fit in during this?
Ms. Norris and I have agreed to set this over probably for an eventual dismissal after a guardianship conservatorship is set up to help manage him in the future.
All right, let's go ahead and, do you want to let her in real quick and we'll take them up? They're together, did I understand?
Yes.
Okay, thank you.
Gary, get over here.
Here we are.
All right, we are on the record now in BU 2025 CR 228, State of Kansas versus Gary Stephen Weaver. Please announce appearances.
Jerry Regier on behalf of the state.
Here.
Darren Patterson, appear on behalf of Gary Weaver. Gary Weaver does appear separately via Zoom audio visual. Hey, Gary, can you remove your hat, please?
They talk of me.
Yeah, take your hat off.
Thank you, sir. Go ahead, Mr. Patterson.
Your Honor, this is a case where I have received a competency evaluation from South Central Mental Health, and I've also have a doctor's report, and it does appear that this is a case that competency is an issue, but we're resolving it through a civil matter and would be doing a guardianship conservatorship. Ms. Norris and I have discussed the case, would agree to continue this, but I'm asking the court not to continue it for trial, but to put it on a docket, hoping that the guardianship conservatorship is in place at that point, and I believe Ms. Norris may be entering a dismissal later on.
All right, Mr. Regier, do you have any recommendations based on communication with Ms. Norris or notes as to how long we should set this off?
One moment, Your Honor.
I keep
Well,
this.
I guess, Jennifer, I should just ask you, what's our next available date?
I don't even know who he is.
That's the judge.
Our next available would be June 29th.
Your Honor,
Okay.
no objection to the June 29th control date. If that is indeed what the court is considering, if the court is prepared to find this as a defense request for continuance, as well as continue the bond previously executed in this matter.
Does that date work for you, Mr. Patterson?
Yes, Your Honor.
All right, this matter is continued at the defendant's request until June 29th, 2029. Mr. Weaver must be back here at 9 a.m. June 29th. And I will continue the defendant's $3,000 bond that he posted May 23rd to 25, the second chance. The condition being that he reappear at that time and that he be available should Mr. Patterson need him or Mr. Patterson's designees. Anything further, counsel, from either party?
Your Honor, is that June 29th for purposes of control?
For control. If I didn't say that, that is a control docket. Or
Nothing
control.
further from the state, Your Honor.
Mr. Patterson?
Judge, nothing further, and just want to thank Ms. Navarro for helping Mr. Weaver be on here today. Thank you.
Yes, we will.
Down where?
We will thank and note that Rhonda Navarra is present as a caretaker for the defendant present today.
Yes.
I
Thank
need to
you
get,
all.
I need to get that car out of my truck out of that garage.
Thank you,
Okay,
Judge.
You're welcome. Mr. Weaver and Rhonda Navarro may hang up. You're excused. Mr. Patterson, anyone else? Oh, you've got quite a few on here.
Judge,
You
I
gotta
believe
make-
Mr. Bill's back.
All right, let's take you
Okay.
back, Mr. Beal.
Okay. We're done.
Can you help them close out, please, Jenna?
Yeah, I'm trying to close this out here.
Yeah, you just hang up on us,
Okay,
basically.
okay. All right. Okay.
Thank you.
June
June 29th, at 9 o'clock. All right, back on the record in 24 CR 542, State versus Beeler. All parties as before. I believe we left off when we were trying to obtain a plea.
It was the
Mr.
factual basis, Your Honor.
Okay, we were having trouble with the factual basis. And how are we doing on that now, Mr. Beal?
Yeah, apparently what transpired was that police were called for gunshots at the residence, and my client, when the police arrived, didn't understand why they're there, had no idea why they were there. He did shoot a gun at the ground and hid the gun casings, and that's why there was interference.
All right. And then did you say, is that right, Mr. Beeler? Is that what happened?
Yes, ma'am.
And when the officers asked you about the shots, did you tell them you didn't know anything about it, or did you admit you were shooting?
I was confused why they were there, so I guess I hit it.
All right. Okay, well, and you know you're giving up, like, again, going over, you know you're giving up your right to trial with this plea of guilty,
Yes, ma'am.
and you will be convicted and unable to appeal your conviction. Do you understand that?
Yes, ma'am.
All right. Well, I'm going to find that you know what you're doing and no one's forcing you to do it, that you're pleading guilty because you believe you are guilty. Is that correct?
Yes, ma'am.
All right. Finding you guilty, I will proceed with sentencing, and let's see if we still have that down right. Your sentence will be 12 months, but it will be suspended. You will not have to serve it as long as you complete a 6-month non-reporting probation. You will not have to see a probation officer, but you are going to be on probation for 6 months, Mr. Beeler. Now there won't
Yes,
be a
ma'am.
lot of conditions. There'll just be a few, but you have to comply with them. The first condition is no violations of the law during this 12 months. I'm not going to give you a fine, and I understand there was no restitution, nothing damaged, but I am going to order that you pay court costs of $158. Counsel, there wasn't any other expense, is that right? Maybe six, no, it's non-reporting, so 158 is the only thing he has to pay. Mr. Beeler, how long will it take you to pay $158? I can give you some time.
Oh no, I'll pay it Friday.
Okay, I'm going to order that you pay it, I'm going to say within 30 days. If you can pay it Friday, that's fine. Go to the clerk of the district court and pay in person. Is that your intention?
I'm out of town working. Can I
Okay.
pay it over the phone or
Well, why don't you, how long are you going to be out of town?
I'm not sure. I mean, I'm
All right.
contract. Yeah.
Well, if you call the clerk of the district court, they can tell you when and how to pay it. You might be able to pay it online. But we have to get a journal entry on file before they can do much about payment. That's why I said I'm giving you 30 days. Not necessarily because you need it, but because Mr. Baca, Mr. Beal, and I may need time to get that journal entry prepared, circulated, and signed, and then back to the court, the clerk who can send it up to speak, and then you can pay online.
Oh, okay. I mean, I can have somebody probably go by there and pay it on my behalf.
Oh, that's fine too, because they can put it in what's called an unapplied account, as I understand it, with your number on it, so that when they get the journal entry, then they can apply it. But
Okay.
talk to the clerk; she'll get you squared away on payments.
Okay.
And I don't believe there's any other recommended conditions other than standard, are there, Mr. Baca?
No, Your Honor.
Wait a second. The story completely shifted. First came claims about defending against an intruder, then admissions about hiding shell casings and confusing police during the investigation. Even the judge paused proceedings because the explanation sounded inconsistent. That breakout room conversation changed everything, and suddenly the plea sounded believable today.
Honor, I think that covers everything for the state.
Oh, and then there's the firearm.
Yes, he would agree to surrender his firearm permanently.
Yes. Thank you. Yes.
All
Yeah,
right.
they took it.
Okay. Oh, they've already got it, so I don't have to worry about
They've had it for 5.5 years.
All right. The firearm is permanently surrendered to the Butler County Sheriff then. And I think that takes care of everything. So just stay out of trouble and you don't have to go to jail, and follow the conditions and you don't have to go to jail.
Yes, ma'am.
Okay, thank you, Mr. Beeler. You may go.
Thank you.
You're welcome. Mr. Beal, you're excused if there's no one else you're here for.
I don't have anybody else, so have a good day.
Thank you. You as well.
Thank you.
Mr. Patterson, are you by chance ready on Riley Batson?
I am, Judge, although I wanted to see if the court could take up the 4 I have at the jail. They're all ready. I just wanted to get the jail free.
Well, they'd probably appreciate that. Who do you have first?
And I
there's
see
Chris
Mr. Pate on here.
Chris Pate, I saw you just in the nick of time. Otherwise, you're going to get behind a long line of Patterson.
Oh yeah, I'd have my video off, but I've been here. I've just got a continuance request on mine.
Right.
Should be pretty quick. It's Amanda Plummer. She just turned her screen on.
All right, I'm going to put you in here then. I'm sure Mr. Patterson would want that to us. All right, we are on the record in BU 2025 CR 554, State of Kansas versus Amanda Dawn Plummer. Please announce appearances.
Jared Regier on behalf of the state.
Your Honor, Chris Pate on behalf of Amanda Plummer, who appears via Zoom.
And she's here on one count of disorderly conduct. How does she want to proceed, Mr. Pate?
Your Honor, this was set for jury trial this week. This is Ms. Norris's case. Ms. Norris indicated to me the state had a witness that was unavailable. However, Ms. Norris and I also discussed the possibility of Ms. Plummer entering into some type of counseling prior to disposition of this case, and the state would take her participation in that into account in resolving the case. Ms. Norris also agreed that she would likely lift the no contact order between Ms. Plummer and Mr. D. Hoff, who is her husband, who is the other alleged participant in the disorderly conduct, but for purposes of participating in couples counseling. I think on that issue, Ms. Norris and I can submit a proposed agreed order. But for purposes of today, Ms. Norris and I agreed it would be a joint continuance request to another date.
All right. Mr. Regier, is that consistent with the notes you've been provided by Ms. Norris?
Your Honor, the state has no objection to resetting this matter at the joint request of the parties, if indeed that is the court's finding in this matter. Insofar as the modification of the no contact order previously ordered by Chief Judge Rickey back in December of 2025 is concerned, the state is prepared to agree to lifting it only for the limited purpose of couples counseling.
All right, I grant the joint request for continuance. This is set over for pre-trial June 22nd, 9 a.m. by Zoom, and jury trial June 24th and 25th live at the courthouse. I will modify the no contact order only for the purposes of couples counseling. Nothing further. Anything else, counsel?
Not at this time, Your Honor.
And if the court is prepared to continue the prior bond to subject all conditions not explicitly modified by the court on the record today, the state has nothing further.
That is the order of the court. The $2,500 personal recognizance OR bond continued to that date with the added condition the contact to only be allowed for couples counseling. Ms. Plummer, you're excused at this time. You may go. And Mr. Pate, is that your only one today?
That's all I have, Your Honor.
All right. Well, thank you, sir.
Thank you.
The judge finalized 12 months suspended, 6 months non-reporting probation, $158 in court costs, and permanent firearm surrender. Instead of jail, the defendant walked away with strict conditions and a warning to stay out of trouble. Like, comment, and subscribe for more shocking courtroom stories.